My name is Erwin Chemerinsky. I'm Dean at the University of California, Berkeley School of Law, and I want to talk about the religion clauses in the First Amendment. The First Amendment begins with the words, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. These are respectively referred to as the Establishment Clause and as the Free Exercise Clause. To a large extent, these two provisions are complementary. Imagine if a state government were to create an official religion and require that people participate in that faith. That obviously, by definition, would be an establishment of religion, but also would infringe the free exercise of religion. Many have thought that if a school were to require students to participate in prayer, as used to be the case, it would be an establishment of religion, but also inhibit, fringe, free exercise for those of different faiths. But there are instances where there's a conflict between the Establishment Clause and the Free Exercise Clause. If the government didn't pay for chaplains for those in prisons or those in the military, it could be said that it was infringing the free exercise of religion for these people. On the other hand, if the government does pay for chaplains, does that then create problems with regard to the Establishment Clause? If the government taxes church-owned property, is that a problem with regard to free exercise? But if the government doesn't tax church-owned property and gives a benefit to religion that nothing secular receives, is that a problem with regard to the Establishment Clause? These are enormously difficult issues, and courts have had to grapple with them for decades, if not centuries. I think it's particularly appropriate to be talking about the religion clauses today because there's a major change afoot from the Supreme Court with regard to them. I would say for much of the last half century, the Supreme Court has had a very robust Establishment Clause. The court has said that it's best understood through the words of Thomas Jefferson, that there should be a wall that separates church and state. And the court has been relatively minimal in protecting free exercise of religion. The court has said there's no exceptions from general laws on account of somebody's religious beliefs. But now I think the court is moving from a robust Establishment Clause to a very minimal Establishment Clause, where relatively little will violate that part of the Constitution. On the other hand, it's moving to a very robust Free Exercise Clause. What I'd like to do is examine each of these clauses in turn, talking first about the Establishment Clause and then about the Free Exercise Clause. But as we go along, I want to talk about the interplay between them, what Chief Justice William Rehnquist referred to, the play in the joints between the Establishment Clause and the Free Exercise Clause. And I hope I can explain how there is a major change going on from the Supreme Court, both with regard to the Establishment Clause and with regard to the Free Exercise Clause. Let me start by talking about the Establishment Clause. I've often thought that this is best understood through the words of Thomas Jefferson, that there should be a wall separating church and state. This was something that Jefferson said at a time when Virginia was considering a tax to support a church. The notion of a wall separating church and state is that the place for religion is in the private realm. Our homes, our churches, our synagogues, our mosques, our daily lives. But the idea of a wall separating church and state is that our government should be secular. Our government should neither be identified with a particular religion, nor in any way hostile to a particular religion, nor should it be identified with religion overall or hostile to religion in any way. In 1947, in Everson versus Board of Education, the Supreme Court considered whether or not the Establishment Clause of the First Amendment applies to state and local governments. After all, it begins with the words, Congress shall make no law. What does this mean in terms of states? Some states still had official state churches at the time the First Amendment was adopted. The Supreme Court unanimously agreed that the Establishment Clause applies to state and local governments. It has applied ever since, but the Supreme Court in doing so also said, with all 9 justices agreeing, that it's best understood as embodying, is implementing a wall separating church and state.